It's an honor to be here with y'all tonight. It's an honor to serve with y'all. I've worked with many of y'all through the years, and I appreciate the opportunity to help y'all. I'm going to get right into the introductions because I'm overwhelmed, and I hope they're listening at what the leadership of the SEC here in Fort Worth did for us tonight. I reached out to one of the enforcement attorneys, Jason Reich, to see if someone might be willing to speak. Never in my wildest dreams did I expect that we would have with us tonight the regional director and two associate directors of the SEC's Fort Worth office, regional office that covers Texas, Oklahoma, Arkansas, and Kansas. I've been looking forward to this presentation tonight because it is about as timely a topic as you can get. How the new administration is likely to change regulatory and enforcement priorities. So thank you to Mr. Peveler, Mr. Werner, and Mr. Gandy for being here. I'm going to just abbreviate their bios. They've got a tremendous amount of public service, which we are grateful for. David Peveler is the regional director of the SEC's Fort Worth regional office. He rejoined the SEC in 2019 after serving as general counsel for a registered broker-dealer and investment advisor. Previously, Mr. Peveler spent 15 years in the SEC's enforcement division, most recently as head of enforcement for the Fort Worth office. Eric Werner is associate director of the SEC's Fort Worth regional office. He heads the agency's enforcement activities in the region. Prior to his appointment as associate director, he worked at the SEC as a staff attorney conducting investigations in the office of chief counsel and in supervisory positions as branch chief and assistant director, where he was a member of the complex financial instruments unit and the public finance abuse unit. Marshall Gandy is senior officer and national associate director of the investment advisor and investment company examination program in the SEC's Division of Examinations. Along with the division's deputy director, he oversees approximately 650 lawyers, accountants, and examiners responsible for inspections of SEC registered investment advisors and investment companies. He also continues to serve as the associate regional director for examinations in the Fort Worth regional office, where he's led a staff of, since 2012, of 45 accountants, examiners, attorneys, and support personnel responsible for examining broker-dealers, investment companies, investment advisors, hedge fund managers, private equity firms, municipal advisors, and transfer agents. So without further ado, I introduce you to Mr. Peveler, Mr. Werner, and Mr. Gandy. Thank you for being here with us tonight.
Thanks, Willie, for the introduction, and thanks, Ron, for inviting us. We're very excited to speak to you tonight. And I'm not going to spend a lot of time laying too much of a groundwork. I think the title says it all. But before we do get started, I want to give our standard disclaimer. The comments and remarks we make tonight represent our opinions. They do not necessarily reflect those of the SEC, the commissioners, or other staff of the SEC. I think this is, as Willie said, a momentous time for the agency. Marshall and Eric and I have each been through administration changes before, from Republican to Democrat, Democrat to Republican, and we certainly are familiar with the kinds of changes that we can expect. To give you a little bit of the table setting here, the anticipated new chairman of the SEC is Gary Gensler. And Mr. Gensler has a very long career in the financial industry. He was a partner at Goldman Sachs and head of their co-head of their finance group. He then served as Undersecretary of Domestic Finance and Assistant Secretary of Financial Markets at the U.S. Treasury under President Clinton. He was chairman of the CFTC, the Commodities Futures Trading Commission, under President Obama, and most recently, a professor at MIT Sloan School of Business with a particular focus on digital currencies and fintech. So he is coming in with a tremendous amount of knowledge about how our markets work, how he thinks they should work. But I think that's not the full story with Mr. Gensler. His tenure at the CFTC was marked by a pretty broad expansion of that agency's footprint. Previously, they kept into a relatively small little corner of the financial services markets, but under Mr. Gensler, they pushed Congress to get broader broader authority over a variety of derivatives connected to commodities. They also became very aggressive, certainly compared to where they were before, in their enforcement activity, and he expanded the size of their enforcement group. So if past is prologue, I think we can all take a little bit of understanding that Mr. Gensler, when he comes in, is going to be an aggressive-minded regulator. And I think that's going to dovetail pretty closely with the two Democrats who are already on the commission. And for those who aren't familiar with the SEC structure, the SEC is a commission. It's a 5-member commission with the chairman or chairperson of the same party as the president. And so that chairperson is the swing vote and sets the policy for the agency. And certainly chairmen do come who are fairly independent of the White House, but as we'll talk about a little bit tonight, I think we can see that Mr. Gensler is going to be repeating and following a lot of the directives out of the White House, not least because I think as part of the president's transition team on the finance side, he may be part of setting what those policies are. So our overall theme tonight is going to touch on some of the key areas where we think the new administration is likely to make changes. And at the end, we'll kind of sum up and we'll have some time for questions. But I think the place I want to start with my colleagues, Mr. Gandy and Marshall Gandy and Eric Werner, for those who have listened to the acting SEC chair, Allison Lee, or Mr. Gensler during his testimony in the Senate last week, the acronym of the day is ESG, environmental, social, and governance. And ESG, and especially the E and the S, I think, are going to be right at the top of our priority list as an agency, at least at the outset. So Marshall and Eric, turning it over to the two of you, how is the ESG emphasis going to play out in your respective programs, and what does it mean for financial executives at companies and registrants? Marshall, why don't you kick us off?
Thanks, David. And before I address that question, I really want to thank Ron and the membership at FEI for hosting us this evening. We have an opportunity in the financial services community to often talk to chief compliance officers, maybe general counsel. And one of the comments that we hear often from compliance programs and compliance personnel is, David, Marshall, Eric, we really wish you would take an opportunity to reach out to the executives of the firm, to senior management in the firm, and tell them some of the things that you tell us, some of the expectations that you have for financial services firms, for public companies in the area of compliance. And so this presents for David and Eric and I a really kind of rare opportunity for us to have a dialogue. And I know in this format, it's a little bit challenging to have a real dialogue, but at least for us to have an opportunity to talk with senior executives on the business side of the operation, not necessarily just concerned with legal or just concerned with compliance, to have an opportunity to tell you what it is that we do at the SEC in Fort Worth and in a broader sense nationwide, but also tell a little bit about what our expectations are now and going forward into a new administration. David has suggested an area of ESG, environmental, social, and governance, and in another real sense, an analogy or another term for that is socially responsible investing. Now, I have 4 daughters, and they're all grown and they're socially responsible adults now. But I remember distinctly when they were teenagers and they would go out, I would often tell them, just use good judgment. Now, I've thought about that as they've grown and I've gotten a little older and maybe a little bit wiser. And I've thought, when I tell them, go out and use good judgment, there's no doubt in my mind that their thought about what using good judgment was different than what my thought was about them using good judgment. And that's very much what we see in the ESG area, or socially responsible investing. What you mean by that may be something different than what a colleague means by that. What you mean by that at your firm or your company may be something entirely different than another company or firm means by that acronym. And so we talk about social responsibility, sustainability, green, ethical, impact, good governance. But like many areas of SEC regulations and the federal securities laws, it's a disclosure regime. And what we mean by that is say what you do and do what you say. So in plain, simple terms, we want firms telling investors, financial services firms telling investors, public companies telling investors, when you say ESG, when you say socially responsible investing or investments, what is it that you mean by that? And when you tell or disclose what you mean by that, then you live up to those disclosures. And that's certainly what we're going to be looking at as the staff of the SEC going forward.
Thanks, Marshall. Eric, why don't you talk about what ESG is looking like from an enforcement standpoint and how that may shape out?
Absolutely, and thank you, FEI, for asking the three of us and myself included to speak to you this evening. Wonderful opportunity. I apologize for the golden hue that seems to be on my screen. I'm not sure if that's translating over there, but this is what happens when you go into a room you haven't used in almost a year. I don't remember what the lighting is like, but the enforcement side is interesting. Following announcements by the Division of Examinations and Division of Corporation Finance, earlier or late in February, the Division of Enforcement announced the formation of an ESG task force headed up by the new acting deputy director, Kelly Gibson, and ultimately laid out some boundaries or framework that the enforcement division plans on following in this space. Ultimately, reviewing disclosure made by issuers, looking at compliance issues for registered entities, and then identifying and following up on tips, complaints, and referrals that are submitted to the commission for review. Following that, or potentially on the same day, commissioners Peirce and Roisman issued their own release, basically saying, we're not really sure what this means and only time will tell. I think they used that phrase, only time will tell. And I don't think they issued that release to try to undermine what the division is doing, but just to try to make clear that this is an evolving area and it may not make sense for enforcement to take the first step in. And I think that's a reasonable approach. But where we start now and where we are a year or two from now may look materially different. As Marshall said, we are a disclosure agency. We are looking for companies to disclose what they think all material information a reasonable investor would want to know. But the disclosure framework that the commission works under is principles-based and materiality-focused. There are several items under Regulation SK that require certain disclosures, but we don't have any required line item ESG disclosures at this point, which is somewhat different than where the UK is going, which has started trying to implement a framework that will require specific environmental disclosures. So we will be looking at the area generally to see how firms and issuers are disclosing what they think is environmental risk, assessing whether we think that's appropriate, communicating either directly from the enforcement side or through the Division of Corporation Finance and the Division of Examinations to determine whether there might need to be more robust disclosure, whether it's accurate based on what we're seeing in other statements the company's made, ultimately to give investors all relevant information they need. But again, how that looks today versus 6 months or a year from now is a little bit up in the air.
And
David, I think it's important to point out to this group. I think compliance programs, compliance officers, general counsel are all well aware, and some of the people in the audience today may be well aware, that the Division of Examinations communicates to the industry by what we call our risk alerts. And last year we issued 8 risk alerts. They are an opportunity for us to talk to the industry through the SEC website, sec.gov. And we've got several of those risk alerts in the pipeline, as you may expect. Before we issue something like that publicly, we certainly compare and get the thoughts from the Division of Enforcement, Corporate Finance, Investment Management, but also the Commission and their counsel. But we happen to have a risk alert in the pipeline right now on ESG, and I expect that that will become public very shortly. So if you want to know what the Division of Examinations is thinking, what the Division of Examinations has found through their examination program over the last year in the area of cybersecurity, in the area of advisory fees, in the area of ESG, several of those risk alerts within the last year are on our website, and they're a magnificent way for us to communicate with the industry, but for you to get a thumbnail sketch of what it is that we're thinking and what it is that we're seeing through our examination program.
Well, I think you touched on something important there, Marshall. I mean, all of this that, you know, the risk alerts, the guidance, the comments, all of that is guidance at this point. It has no direct effect of law in the sense that we can't say, well, we issued this guidance and you violated what we said, so that's a problem. That's not how it works. There has to be a rule, there has to be a statute. And the SEC's last, I guess, official discussion or release on ESG was really, I guess, 11 years ago. And so things have changed then. I think the views of the investment community, of the financial community of public companies have changed. So I would expect one of the first things you're going to see is more guidance, more precise guidance on what the risks are that we think companies should be focused on in terms of their disclosures. I think the other thing you would have to see if this were going to really turn into a broad area for enforcement is probably some stronger rulemaking, simply because the way our rules are written and the way the accounting and disclosure rules are written in the U.S., and I'm separating what may be the case in international accounting, are not really driven towards those kinds of precise disclosures. But I think ultimately what we're driving at as an agency is that the risks of climate change, for instance, have become more evident to companies, particularly those in certain industries like the oil and gas industry or other extractive industries. But even beyond those kind of straightforward risks, there's simply the impact from laws that have changed around the world. There's the focus of different treaties and how that's going to impact your business, the impact of your customers and your vendors what kind of expectations and contractual requirements they have for your business. And the list could go on and on. Each business is going to have its own assessment to make. So I think the specific guidance here is the agency is going to be expecting companies to be aware of those risks, to identify them where possible, and where quantifiable, to quantify them, but to let the investor know about those risks, because there is data. And if you look at some of the speeches uh, that the acting commissioner Allison Lee has given in the last year or so, there's a number of data points cited about how important ESG disclosures have become to investors. And so from our standpoint, when they are important to investors, they certainly become very important to us. Let me move on to another very hot topic that was also covered during Gary Gensler's Senate testimony, and I think I saw a couple of the comments pop up here, questions, and that is the meme stocks, or most appropriate or most directly, the GameStop circumstances, where you have the group of Reddit board members posting things and investing and making some amazing impacts on the markets over the last 6 weeks or so. So Eric, without disclosing the details of any investigations that may or may not be underway, if you're a CFO of a company like GameStop, let's don't use GameStop, but a company whose stock value has been run up because of a message board, and taken on a roller coaster ride, what are some of the pitfalls you would want to avoid, at least from an enforcement standpoint?
Thanks, David. And it is, I've been with the SEC and in the securities industry for over 20 years, and this is one of, if not the most interesting events, circumstances that I've had the opportunity to learn about, be a part of, and I equate it somewhat to cryptocurrency a few years ago, that it started as a lower level issue, but quickly gained steam. But when my mom asked me, Eric, what's Bitcoin? I knew that it had been much more pervasive and had reached a certain level within the community outside of just investment. And GameStop and the other meme stocks have reached that, and it reached it much more quickly in the period of days, potentially weeks, but really days for most people. Went from that's an interesting article that I saw in the New York Times or the Wall Street Journal, to everyone either wanting to talk about it, saying this is crazy, why isn't the SEC doing something, why should the SEC do something? So from a personal perspective and somewhat professional, it's been fascinating to follow all of the articles. And as David said, without getting into any information that I may happen to know about investigations that exist into this area, what has been interesting, and I've talked to my colleagues, is, first and foremost, does any of this violate the law? And if you've been paying attention to any of the news media, people think it violates the law. It doesn't feel right, but no one's come forward with an actual allegation that it has violated a specific rule or statute that the SEC enforces. That doesn't mean that the SEC or people outside of the SEC aren't trying to figure out whether it violates the federal securities laws. People just aren't really sure, because it is a fact pattern that we haven't experienced before. And I'm not sure necessarily that we weren't prepared for it. It just happened so quickly with so many people. So in looking at where a public company intersects with this trading, one of the issues that we thought about is, are insiders taking advantage improperly of the increase in stock price? And improperly is really the most important word here. There may be no problem if a senior executive wants to sell stock or exercise options at a price that was $10 a month ago, but is at $100 now. But that doesn't mean there isn't a problem either. And I think companies, from general counsel to looking at policies and procedures as to when can we trade, Do we have 10b5-1 plans implemented? Are we trading inside or outside of any blackout periods? Because it may be that such trading is legal and proper, but a lot of people are looking at it, and especially people who might be losing money on the other sides of these trades want to find a scapegoat. They want to point fingers at people, and first on top on that list are people who are making money off of this. Companies themselves need to be careful about accessing the capital markets, selling stock into these inflated prices. Are they, and the Division of Corporation Finance issued a letter a couple weeks ago that they planned on sending to any company that had a pending registration statement or was thinking about accessing the capital markets, essentially going through, are you properly disclosing risks associated with this fact pattern? Are you talking about where the share price was and where it could be? Are you talking about what social media has done to your company? Are you interacting with social media or not? What are the known risks of your company's stock? There are a lot of pieces to this puzzle, and I think this all harkens back to what Marshall said earlier, is as a disclosure agency, the commission really looks at this and wants to make sure that companies are disclosing all relevant information, and if not, that they don't take advantage of this potentially artificial increase in price of their stock. But if they are fully disclosing all known information and risks, then on some level, and I think it's yet to be determined, there may not be any violations of the federal securities laws involved. So obviously this is unfolding and developing every day. I believe GameStop was up another 50 points today, and is from 10 to 400 something back down to 80. Is now over 200. So that is just one of many stocks that has been impacted by the scores of Robinhood and other social media traders.
And before I ask Marshall about what the Division of Examinations is doing in this area, one thing I would add to that is the in his testimony, Gary Gensler talked about the fact that he was going to have the agency looking at what could be some of the systemic issues that came out of this or caused this. And the ones he highlighted were payment for order flow, the options pricing mechanisms, short selling rules, and just the overall market structure. Because I think, as Eric alluded to, this could be one of those perfect storms if you really trace down all of the different moving parts and how each one contributed a little bit to the momentum that this stock price movement, how it occurred. And while any one of them may not have been meant a problem or illegal, the fact that you have these kind of wild swings does suggest something that the agency needs to look hard at, because it does create a level of unpredictability, and it undermines, in my mind, some of the credibility of the market. That if the value of a company that was priced here for a long time suddenly and for no clear reason rockets, to use the emoji of the Redditor, rockets to the, takes off, then that does raise a question of, is there some systemic issue? And with somebody like Gary Gensler, I would expect us to really get into the market's plumbing and figure that out. But Marshall, let's talk a little bit. What is the Division of Examinations looking at in this area in terms of investment advisors, hedge funds, and broker dealers?
I will be 69 years old next month, and I've been at the SEC now for 22 years, a second half of a legal career that started out in the Dallas criminal justice system. I do get asked every once in a while, Marshall, how much longer are you going to do this? And my answer is quite simple. I get to learn something new almost every day in this job. When I came to the commission in 1999, I was presented with this huge book of federal securities laws, and I thought I had to consume the whole thing inside of my first month that I was there, and I learned very quickly that that's not the case. It's incredibly exciting to me to be able to learn new areas of the financial services system, the investment community on a day-to-day basis. And I mean, we quite honestly, for the last year, the Division of Examinations and certainly the entire commission has been drinking through a fire hose. We said nothing could top 2020. And then came 2021. So we've been dealing with the issues of market volatility. And while Eric on the enforcement side is looking specifically at violations of the federal securities laws and whether or not through their investigations, attention needs to be brought by the commission through the federal district courts or the administrative courts on violations of the federal securities laws, the Division of Examination through its examination authority is going in and looking at the financial services firms and how they're dealing with this market volatility. This time last year, we went on remote work. All the examiners have now been on telework for the last year. I've gotten very accustomed to dealing with the outside community and with the examination community by this format alone. And I will tell you, for the first month and a half, I didn't turn on my camera. I wasn't used to it. And now, you know, this is probably easily the 8th video conference that I've been on, either internally or externally, just today. But it gives us an opportunity within the examination community to reach out to various and sundry business models, to ETFs, to mutual funds, to investment advisors, to investment companies, and understand how they are dealing with the market volatility. First, the market volatility that came as a result of the global pandemic, and then the market volatility as a result of the meme stocks. And that's a really interesting opportunity for me in being able and having the privilege of running the investment advisor, investment company examination program across the entire nation to learn how the market deals with events like COVID, events like the meme stocks. And people look at David and Eric and I and somehow assume we are market savants and we understand exactly how the financial services community and the investment community, how it operates on all different levels. And I'm going to tell you a secret and a peek behind the curtain. Nothing could be further from the truth. The three of us, even though we've probably got 60 years plus experience between us, we're learning something every day. And it's the opportunity and really the privilege of being able to interact with professionals like the FEI, like the NSCP, like the ICI, and professionals within the financial services community, for us to be able to understand how you serve your investors and your customers at very volatile times like we've experienced over the last year.
Thanks, Marshall. And I think for the interest of time, we may jump ahead in our outline and talk real quickly about how cybersecurity risks are likely to be treated under the Gensler administration, um, and not just. So I think as this has become a much bigger and broader problem every year, it seems like we keep thinking we've reached some sort of peak and then we top it. And I think the answer is, as many of you probably know, it's not a question of if you're going to be the subject of a cyber attack, but it's a question of when and from what direction. But Eric, I wanted to give you a chance here. How do you expect the Gensler Commission to approach this area in terms of enforcement? Because historically, we've looked at most companies, not all, but most companies as victims and have not pursued from an enforcement standpoint. Do you see that policy changing at all?
Uh, I think it may change a little bit. This is, as with a lot of these issues, an evolving space. But um, what I think that the incoming chairman Gensler is going to bring to the job is a pretty acute understanding of cybersecurity, cryptocurrency, digital assets, a lot of modern technology. And a colleague of ours pointed me to an online class at MIT that is free for everyone that then Professor Gensler taught in cryptocurrency and fintech. And what struck me was a pretty deep knowledge of some fairly esoteric issues. And this was back in 2018. So 2.5 years ago, he was talking in detail about blockchain, cryptocurrency, private ledgers, words that back then I probably had not even heard, and he was teaching classes about it. So I think he's going to come into the job with a perspective that prior commissioners and existing commissioners have not had, but an understanding of, not only what risks companies are facing, but also what steps they are able to take to combat those risks, and an effort to make sure that companies are taking those steps, disclosing what steps they are taking, and making sure that investors know both of those things. And obviously, it will play out, and maybe some other issue comes to the fore and becomes more important. But as you said, David, it's not a matter of if, it's a matter of when, and how companies react, how they disclosed, what their internal controls and procedures were, and ultimately whether that was sufficient based on the known risks at hand. I have had the luck to work on a couple of these cases, both that we brought and some that we did not bring. And my perspective has been, and I think the Division of Enforcement's perspective has been, we're not looking to crush somebody. We're not looking to sue somebody if they gave their best effort. But whether it was their best effort or not is the issue that we need to investigate. And on a lot of cases, we found that the company did. It hired outside counsel, it hired other companies to come in and scrub their internal controls, to look at their disclosures, to make sure that they were doing the best of the best and best practices. But we also came across some that hired some of these firms, didn't implement their suggestions, got hit, and ultimately the disclosures in their 10Ks and Qs didn't match up what they claimed they were doing, and they ended up getting sued by the SEC. So I think that understanding what it is the risks are, making sure that the company is taking appropriate steps to combat them. No one's going to be perfect, and if these cybersecurity attacks happen, it's almost guaranteed that there will be some harm to the company. But we want to be the company's last problem, not their first problem. So if they handle it appropriately, we are happy to knock on their door, ask some questions, and then go on and do something else.
And Marshall, from the regulatory standpoint, I think cybersecurity has been on the exam program's priorities list for maybe 6 years or 7 years, something in a row, and it's back on there this year. So what are you seeing this year in terms of cyber as a risk, and what firms should be doing?
Yeah, we started out with the first cyber priority in 2014, and we are now launching into Cyber 4 this year as a priority. And look, I eventually want to really wind up where Eric did. I'd be more than a little disingenuous if we got too preachy about cybersecurity, because the federal government has been the victim of cyber attacks, and in fact, the SEC has been a victim of cyber attacks also. And so it really is, we want to sound the theme that we, through the examination program across the nation, are trying to help firms when they, in fact, may be the victim of a cyber attack. And you notice that I'm using the word victim very decidedly, because as both David and Eric have said, it's not if, but when. But we only have 1,000 examiners in the Division of Examinations. And yesterday marked a milestone where we now have 14,000 registered investment advisory firms with the SEC at this point. So do the math. We can't get everywhere. So as we launched our Cyber 1 in 2014, it occurred to us that what we might do is publish our document production list and our questions that we were going to be asking to the firms that we were going to examine, publish it nationwide, and give firms an opportunity, CCOs, GCs, CEOs, to look at this and say, well, if the SEC came in to examine us, how would we do? How would we answer these questions? How would we be able to produce these documents? And really, it's become a template now that we have used over and over again in the last 7 years, of a way to speak to the financial services community, not only doing an exam, but the kinds of things that we find in our examinations and look for in our examinations, so firms can prepare. I think the thought that I would want to leave public companies with and firms with is, this is not an area that you can simply go out, retain a third-party vendor, and walk away and expect that third-party vendor to take care of your cyber needs. Early on, when we were examining for cyber, we would ask firms, well, have there been any attempted intrusions? I don't know. What did the third-party vendor do in reaction to any attempted intrusions? I don't know. We left that up to the third-party vendor. You're at your own peril as a public company or a financial services firm to simply farm something out, compliance, back office, cyber, and expect that to be your answer. We farm that out. We don't know what happens. You're still responsible as a firm and a public company to know what it is the vendor is doing to protect you. And answers like, I don't know how many attempted intrusions there were, I assume that none were successful because they didn't tell us, is not a sufficient answer.
Thanks, Marshall. And I think we're kind of getting near the time they had allotted, but want to move to questions. And I think if it's okay, I don't know if Ron or Nancy have a different view, but I thought I've been jotting down the questions that have popped up in the chat, and there may be some. So maybe I can address a couple of those, and then Ron, we can pick up a question or two from the live audience.
That would be great, Dave. Thanks.
Okay. A couple of these, I think I can start, right at the beginning, we were talking about ESG and some of the burdens that I think public companies see in that area. And I think one of the questions: can a company's setting certain criteria for selecting board members be used against them? Again, not here to give you legal advice on those points. I would say that not everything becomes securities fraud. The fact that you set certain criteria, you try to follow them, there may be investors who decide that you didn't follow them well enough, or you follow them too well, and they may bring derivative claims or something of that sort. But that's not something the SEC that I can ever think of has focused on very hard, those kinds of corporate governance decision making. You may see that more with the exchanges themselves. You may see that in terms of shareholder proposals and things of that nature. I don't see that as something the SEC is going to be really jumping in and trying to make any kind of activity on. I don't know if Eric or Marshall feel differently, but let me move to the other, and because I thought this was a little more interesting, the power of ISS over proxy season in particular. And that was an issue the last commission actually got pretty active on, and did some rulemaking in that space, which kind of indirectly affected ISS in some ways. But that is an area I expect is going to shift in the other direction. I think that this commission, if I had to guess, is probably going to be more willing to have activist shareholders, or in this case, a shareholder proxy of sorts, if you want to, not to use that term improperly, but just someone who makes recommendations to other investors. And so I do see that tide shifting back in that other direction. I know that may not be music to the ears here, but that's my best view of that, how that will play out. And then the last one, kind of along this same vein, is what is the SEC's view, or what does it do about companies that are in unpopular or socially, at the moment, unpopular industries? And do we do something to limit their access to capital markets and so forth? I mean, you have to remember, our whole securities market structure in the United States is different from, say, the United Kingdom. The SEC does not pick winners or losers. We don't tell you can invest in this and you can't invest in that. What we do require is companies make fair and complete and adequate disclosures, accurate disclosures to investors. And so if you are in an industry, let's say, the tobacco industry or the alcohol industry or firearms or, cannabis or whatever it may be, you need to be making full and fair disclosure of the risks associated with your business, uh, associated with your revenues, with your assets, with your prospects. That's what we govern. And I don't, it's not a situation where we're going to say, you know what, we don't like the oil industry, so we're really going to apply some different standard to them. That's not how we work, and that's not going to change under Gary Gensler. Now, we may put an emphasis on particular kinds of risks and disclosures. And I think that's what you're going to see with some of the ESG initiatives. But it's ultimately has to come back to the regime that we have. It has to still go back to full, fair, and accurate disclosure. So I don't know if that answered the question exactly, but that's certainly how I perceived it. And before I turn it to Ron, Eric, Marshall, I don't know if you guys have any particular things to add on those questions.
I don't, David. I thought those were good answers. Thank you.
Yeah, I agree.
Okay, real quick, are there any questions in our live audience? Tom?
Many companies are making claims they'll be carbon neutral by 2035 or 2040 or some point far out into the future. Yet many of the enforcement folks at the SEC and even in those companies probably won't even be around in 20 or 30 years. What responsibility do they have, and how much detail or support do they have to make available for those types of claims to the market and to investors?
Well, I'll go ahead and take that question. The morbidity built into that question is a little depressing, but
Yeah, I take offense at that. I'm going to be around.
The only thing I would say is this is this is an area I think needs development in the sense of what is what is enough to have a good faith basis for a projection that's 15 or 20 or 30 years in the future. An analog that I would give that I'm familiar with is proved reserves reporting in the oil industry, where you're typically looking out 20, 30, 50 years to determine what may be under the ground and may be producible over that time frame. And in that instance, we do have some pretty specific rules about what is required to be disclosed and what is required to meet the definitions and standards that we have in that area. And there's a pretty robust set of science that is built around that entire industry. I don't know that the science is quite as robust on some of the other aspects of of the environmental and climate change related disclosures. And so from the standpoint of what would be enough, I don't think we've developed that. There's certainly not rulemaking or I'm sorry, not rules in place that say specifically you must do X, Y, and Z. I think it goes back to what Eric said earlier. Is it a good faith and supportable projection, or recognizing that it is a forward-looking statement and it is an opinion about something, both of which receive special protection under the law. But I think at this point, each company, each industry is going to have some different things to apply. So that's probably a non-answer answer. But I think if I'm sitting here as an enforcement attorney, I'm going, gee, how would I prove that in court that they didn't have a good faith basis? And if the answer is, well, they didn't do anything, or they just, stuck their finger in the air and saw which way the wind was blowing, okay, I can probably prove that. But if they actually, did what seems reasonable, comparable to their peers, it's based on good faith estimates and projections, then I'm going to have a lot harder time saying there's something wrong with that.
One of the analogies that I might draw is in the ESG area, we've seen firms that as ESG related have said, we're going to donate a portion of our profits to some type of nonprofit charity. And that's all fine, well, and good. And we certainly don't make any judgment calls on that, save and except the fact you go in and you look at the expenses involved. And after the expenses are paid by the firm, there are no assets left to be able to make a material donation. So if the disclosure is we're going to be making charitable donations through our investment vehicle, but there simply are not assets that would allow for that to be a material fact, then that's something we're going to raise a question about.
Any more questions in the audience? We have time for a few more. We're actually supposed to finish at 7:30, but I looked at the run of show and it looks like from 7:30 to 8, they have my closing remarks. So I guess I get 30 minutes. No? Okay.
Well, Ron, we've got a few more from the chat board we can pick up here. I think the first one here was and again, I'm paraphrasing these, so if I missed what you're really driving at, I apologize. But with regard to cryptocurrencies, how does the SEC look at them from an enforcement standpoint? And I think maybe connected to that, do we think there'll be any shift under Gensler? And Eric, I think you're perfectly positioned to answer that.
Well, as with most things, it feels like I've answered today. I think cryptocurrency is an ever-evolving area or landscape. But cryptocurrency is especially that because as the commission has reviewed and disclosed, as it looks at digital assets, cryptocurrencies, the commission itself has said that it could at one point in its life cycle be a security, and at another point in its life cycle, it could not be a security. So working with any medium of investment that can evolve or change over time necessarily makes the enforcement of any violations of securities laws very difficult. Case in point is probably the commission's lawsuit right now against and I can't remember the name, not Ether, but David, you may remember. I apologize. But it is the commission filed a lawsuit alleging that it should have registered its offering. Ripple, excuse me, there we go. And there are arguments that, SEC, maybe if you had filed this 2 or 3 years ago, you would have been right. But when you filed it now, you're wrong. Or, even if it was, and you're alleging violations from 3 years ago, because it's not a security now, why are you even in this space? So I think the commission is going to have to walk an interesting line in determining what in fact is a security in the cryptocurrency digital asset space, and whether it's appropriate for the Division of Enforcement to file a lawsuit. I think that we will be aggressive here. I think that based on comments that I've heard from incoming Chair Gensler, he is aware of the growth, phenomenal growth in this space, the risk to cryptocurrency investors. And because the SEC's job, at least a third of it, is to protect investors, we need to be in that space and making sure that we are being aggressive and pursuing a robust enforcement program. That may evolve over time. We may end up looking at small newcoming securities to make sure that they're disclosing all relevant information as they access the public markets. We may find out that a digital asset is involved in a long-running fraud, but may not be technically a security. So at that point, I think we will work with our law enforcement partners, criminal agencies, CFTC, others, to find out, do they have jurisdiction over this, and can they get out in the markets and file a lawsuit and protect investors? But I do expect a lot of collaboration between regulators, both criminal and civil. I think that the SEC will be a primary player in the space, and you will see a lot more public announcements and discussions about digital assets.
Thanks, Eric.
I appreciate it, guys. We're actually about
You out of
8
time?
minutes
Yep.
over. Hey, I really want to appreciate David, Eric, and Marshall on a great program. I've been in FEI since 2011. I think this is one of my favorite programs of all time. Thank you for the quality presentation, and thank you guys for being here. It all started out with a call to Willie asking for some help getting to a speaker on the SEC, and he referred us over to Jason Reinich, and Jason kind of moved us on to David, Eric, and Marshall. So we couldn't believe our luck. So thank you guys again for the great presentation, and we hope to see you sometime in person once the pandemic is over. Thank you.
Thank you for having us.
Yes.
Absolutely, thank you.
And I guess we're ready to close down the program. We do have some post-event networking. If you want to hang around and network a little bit, feel free to. Thank you all for coming.